and you are Frank, keeper of who might be on Zoom that could help us determine that.
I would say yes.
Okay.
I have not taken an accounting yet, but I will.
Yeah, if you don't mind, if you will, when we're done, make sure we have a list of who attended this meeting, and that way. All right. Okay. Well, great. Thanks to everyone who's here and those of you who are on Zoom. We will go ahead and proceed, and we're going to start with the meeting minutes from our January meeting. Did those? I think we circulated those previously to everyone by email.
Yes.
And I hope people had an ability to take a look at those. And do I hear a motion to approve those minutes?
Moved.
Okay, so moved and so seconded. So all in favor?
Aye.
Aye. All right, those, we will have accepted those minutes. Okay, and I want to introduce our new liaison, Justice Hawkins. It's so nice to see you. Do you want to say a few words?
Thank you. Yeah, I'm honored to be here. I'm thrilled to be the new liaison to this committee. I was appointed to the Supreme Court by Governor Abbott in October. So I'm still the new guy on the court. I'm still learning, where to park my car and all that. But I'm loving being a member of the court. I'm deeply honored to have the chance to serve my state. And I'm looking forward to being a part of this committee. I think the work that it does is critically important. The Supreme Court values the work that you're all putting in and your input, and I'm grateful to be a member of this. Look forward to working with you.
Thank you very much. We look forward to having you and getting your input. So that'll be great. At this time, we're going to do our committee updates, and let's look at the, do you happen to have these, any of the standards on your computer?
I do.
Okay.
You want me to open the draft 11 standards?
Yes.
Yes.
Okay.
Yeah,
And I'll let
let's
start with
confirm to everybody what we've added to what will become
Hmm.
11.
Okay, so what we have here started as the 10.1 standards that Casey started, which were never fully adopted, then is now the 11 standards, which has a few additional items, and I'll just scroll through. The items are highlighted. You can see here the revision history in green from 10.1, and yellow is what we're adding along with the green in version 11. And then scrolling down to those items. So this has been covered. The artificial media, I think we're good with that, right? And new in version 11 is the summary judgment elements. Any questions or concerns before I scroll down? There's a few other minor changes. No? Okay. Same thing, motion for summary judgment and response in 422. I'll just keep going. Bob said a moment ago, we need to check these columns, right, Bob?
Yes.
Okay, so I'm gonna add that in real time.
Do we know if there's any statutes that are making anything in those case files confidential, or are we just allowing the attorneys to file them data sensitive and stuff about it?
Well, and right now, as you know, we're going through and reviewing all of the rules and statutory access restrictions. And so we'll come back and deal with all of that at one time.
We'll leave that till I'm just
I
verify.
think that's it.
Yeah, that's it.
One trivial point, in justice courts, it's called summary disposition instead of summary judgment. I don't know if that affects anything.
Well, if it's different, then we need to.
It's just titled different.
Well, are those motions governed by Rule 166A?
And are they just, I mean, are they governed by any, is there a specific, I don't remember, do they have a specific rule relating to them? Is that how we know what they're titled? Or are they more just motions that are presented and you all categorize them? It's a matter of course.
I'm not sure I know how to answer. The 500 series rules were changed this last legislative session. And I think in there may have been slight recharacterization, but the title, and I think 166A still applies. But there may be some additional things.
Yeah, I just wonder, is it the course, it's more a course of practice to say summary disposition, or is it an actual somewhere that terminology is found?
I want to say it's both, but
And we need to look at that.
mostly terminology, but yeah, we may need to look at it further.
Yeah.
Here, I'm sorry.
Yeah.
Go ahead.
No, I was just gonna say, different places may have a different course of practice of how they refer to them or whatever. If it's a designated and in writing in a statute or a rule or something like that, then I'm thinking we do need to add that.
I mean, same principles are that you have for some judgment or their summary disposition.
Okay.
My question is, does the statute apply to those types of motions? Well, JP.
Right, because we're adding it because they're on a timeline. Yeah, because the judges are on a timeline as soon as those get filed.
Oh, that's right.
It's 21 days.
How soon we forget. Okay, so do you
have to have
follow
your-
the 166 rules relating timing, like motion, this is when your response is due, this is when you're hearing?
All I can say is I did when I was full-time before and retired, but I can't tell you I don't even know what changed in the 500 series rules.
So they have to, so there's a time deadline now in place on the judge taking those up and creating this timeline as soon as they're filed. And so I don't know if the JP courts are following that, or if that is
I can look into that.
demanded of them. I don't think they do. I don't think we put that burden on people down at the JP courts, but you know what? That would be great if you'll check on that and confirm that for us.
I'm almost positive they still follow the 500 rules on that.
Yeah, at the same, okay, and yeah, and
You would know.
It's okay.
right, and and I don't have, I looked at my thick book that has all the rules, and I thought I'd throw it in my briefcase, and I didn't do it, and now I'm sad. But yeah, I'll just take a quick look at that as well. But yeah, you'll know, and so thank you. I'll look at the 5. Were those changed? Did they import the new rules that they have for?
They did, but I don't think it had anything to do with that.
Okay.
A lot of the changes had to do with like squatters and that kind of, a lot of that kind of stuff, but I don't think it had anything to do with that. I mean, I would have to double check as well, but I'm almost positive.
I would just think that would be so unusual to put a very complicated time frame down in JP court on people. But who knows? Yes.
Yeah, I drilled down, I found the
Thank you.
statute. It says the business court, a district court, or a statutory county court shall, with respect to a motion for summary judgment, and then sets down
Oh.
those.
So,
I'm thinking that adding those codes was as true. Now the courts have to really be super aware of when the motions for summary judgment are filed because they have these strict deadlines. So it may not be,
doesn't look like it applies to the JP.
the statute doesn't say.
Yeah.
But we should add. What term are
Summary
you?
disposition.
Summary disposition. Distinct.
All right, for in purposes of
for
this
justice
particular,
courts.
yeah, okay.
And maybe, can I suggest putting in the parentheses JP? Because we're gonna have clerks that miscode. We
Other
already see it,
things,
you know.
yeah,
see-
I agree. That was my concern about putting different terminology that might be easily.
Yeah,
But what does that do for JPs that actually use summary judgment and not summary dispositions?
I don't know, I'm pointing out for the
Well,
courts that have
something
these
is
reporting
filed.
requirements.
So this is gonna apply to a system, right? The system that are in the computers and things like that at the county level to know what to label it or whatever. So I don't think that changes the way, I mean, if a lawyer files a particular motion, how that will be dealt with, I wouldn't think.
I can
I
tell
don't
you
know.
that many practitioners would file a motion for summary
Yeah.
judgment in justice court. And so that doesn't apply. It's a summary disposition. And it went into effect definitionally back in 2013.
Okay.
So it's been around for a long time. But I don't know what changed in the last legislative session.
Why don't we take a look at that, and if you don't mind kind of asking around, that'd be great. I think that we'll bring it up, but it sounds like to me we need both, but it also doesn't sound like a bad idea to have a parenthetical JP
Oh, I agree.
so that it's not some vague motion that people start filing things in the district court level.
I mean, we
Well,
have,
I think in the technology standards, isn't there a JP section for JP cases?
I don't think there's that, but
There's not a separate
there's
section.
a section, like some of the terms actually have for JP courts next to them, so if that's in there, like I know landlord tenant eviction stuff says that. So if that's in there, we would
That's-
know to configure
yeah.
that
Okay,
at the JP nodes only.
perfect. Yeah,
I'm
that
just,
sounds,
so that
Yeah.
the person who's entering this stuff and picks the code doesn't pick the wrong one. That's all I'm suggesting. It happens already.
okay, so we'll look at the 500 rules just to become knowledgeable about that for the JP courts. But basically what we tentatively are deciding, and we can bring this back up at our next meeting and confirm it, but what we're tentatively deciding is that we will have this add the summary disposition, but then do the parenthetical, whatever language we use for the other JP applied rules in that one. How does that sound? And then we'll put it down for next time, unless you need us to vote on that now. Are we voting on all
Well,
of these?
With the exception of this one, the changes we're recommending come from statutes that have already been enacted. And in fact, one went into effect March 1st, which places responsibilities on the clerk.
Right.
So, and in fact, when we finish with this, I'm going to make us another suggestion on how we handle changes that are the result of statutory change. But I would think we would go ahead and move this and get this update in there.
Okay,
Given that we're behind the gun anyway on keeping these up to date with the current statutes.
okay. And so I don't see any downsides. Anybody know any downside to inserting summary disposition with the JP inclusion, making it similar to the other ones that we have on the list?
Yeah.
Right, and Bob, who is gonna put in that language? I mean, what language you want me to do that? I'm happy to take that on.
Yeah, you
Okay.
or
Yeah.
uh,
I'll just look at what the list has for the other ones, and so
And get it to Frank.
All right, so can I hear a motion then on
So
this? All right, so the motion is basically that we go ahead and include summary disposition with a notation like we have done the other ones, that this is only applicable to the JP courts. And with that then, and we've gone over all the other highlighted ones that we have added or changed. And they're ones that we discussed in previous JCIT. Now just brought them all together and put them on the list. And that doesn't mean we can't update them as we go along, but right now we think this list, then Bob, according to your committee, believe that this is the best and final list that we have for today.
that is correct.
So this is version 11 we're voting on.
Yes, sir.
Bob moved on second.
All right. All right, all in favor? Aye. Anyone opposed? All right, with that, it passes. Is there anybody online that's voting that we need to hear from so that you'll know what the vote was on that? So we know we have a. Okay, down
They
Zoom.
can come off mute if they'd like.
Do you want to come off mute and vote? Anyone? Or send us an email that you voted?
This is Todd Smith. I'll vote aye.
Okay, thank you, Todd.
Mhm.
Anyone else want to jump on and vote? All right, well, we'll leave it till the end of the meeting and we may come after the meeting to get some more votes on this. But right now, I think did we make a note of who voted here? Can you raise your hands again if you voted aye? All right, thank you. Okay, just do this.
Somebody gave us a thumbs up.
Okay, who gave
Ed Wells.
Okay, great. Let me just make a note. Okay. All right, so this is standards. Okay, so now this is approved and will go before the Supreme Court. Do you want to address some more standards?
Yeah, one of the things that we had a standards meeting on March 13th. And had a very interesting discussion about adding documents to criminal. There were no specific suggestions made, but it led into a broader discussion about what documents are restricted by either rule or statute, and are we up to date in the way the matrix is designated. So we have a project now to review those. Tracy sent us the results of a meeting that we had in 2019 and a couple of others, and we're going to be working to double check what we have here against the statute and rules that we are aware of. One of the things though that came up in that discussion though was, and that I want to remind everybody of, just because we add something to research a document, let's assume we add at some point the rest of the criminal file, which has not been proposed. Let me make that clear, but hypothetically, let's assume that occurred. That does not automatically grant access to registered users, the public, or anybody else. We control access through 5.1. If you recall, last year, we updated and created some new roles that specifically identify, for example, judges, appellate judges, remember all those discussions, specifically what their access was or is through research. So again, just because we add something to research does not necessarily mean that registered users, i.e. the public, will have access to them. And we will report back at the next JCIT meeting if we have any changes that we're going to recommend.
Right, well, we have to review for the criminal documents. If we're heading toward the criminal documents, we actually have to review those statutes and things regarding all of those. And that one's kind of open. I feel pretty good about the access on the civil stuff. We did a complete review of it. We're in the past, and now we're we're starting over this year after September of last year to just see if anything new or different came out of legislation. It can be very obscure. I mean, might not be on the level. So we may end up learning as we go along that some things, access has been either expanded or diminished based on what the legislature did. But it's the criminal ones. And Cynthia, I would ask for a little bit of your assistance. That's a little different area.
Yes.
You know, a lot of people are uncomfortable. There are a lot of criminal files that expose very nasty acts and very bad things about people that are available to the public. They are considered public documents. They're not privileged. They're not withheld. They're available if you go to the courthouse and get them. And so it makes me a little squeamish to make them all out accessible to everybody in the world, including somebody's, sixth grader online looking for junk against his enemies, nemesis in junior high or something. Anyway, go ahead.
Are we receiving guidance on our standards for what we can release? I certainly understand as our role as JCIT, our role is the overseeing of electronic filing.
Yeah.
When we're discussing what information should be available to the public, we're talking about First Amendment issues and legal issues about what we're legally required to do, what we can do under certain time, place, and manner restrictions, and other factors. I think we're having a lot of discussions about what we can do on the release side, but I don't know if we're getting any support on that side of getting guidance from what we're legally required to do.
Basically, I know that Dan and I and other clerks who have kind of looked at this and their own, even starting with paper in terms of what people can see and not see. We did have a little bit of guidance from the Supreme Court through our former, liaisons and that sort of thing. But we've pretty much taken the tact that on document availability, the courthouse is open. And if a district clerk would have given you paper, normally we give you electronic. It's not because there should not be a change in posture unless we really consider it.
Well, that's certainly my position. And
I think that's a district clerk's practice and procedure for the most part. I mean, they have a lot to say about all this. And county clerks and everyone else. I mean, so we don't want to be determining necessarily what the law is. But in fact, from the get-go, from the way we started with the filing and everything else. We basically made the recommendations to the Supreme Court and more or less relied on them as well to help with those policy decisions. We don't make any policy on our own. We basically, it ends up in the Supreme Court in terms of this is generally what we're doing. And they can either yay or nay. And so we can.
Yeah, I think where we're going to need to be really careful. There are statutes and rules regarding restrictions to personally identifiable information. Juror lists, witnesses,
Victims.
kids, victims. I mean, there are a variety of categories that are defined, which may end up being more of a discussion about what gets redacted and where in the process does it get redacted. And how do you provide for lawyers on the case a clean, as filed document? But if it's accessible beyond the lawyers, the judge and the lawyers on the case, where does redaction occur? And those are there's both policy and process involved in that we're gonna need to work through. And
I think
eventually make some
I think what
recommendations.
you just said on when that occurs is an important discussion too. Does that happen at the system level? Do we rely on the attorneys to do it? If the attorneys don't do it, do we back up and do it on their behalf? Do we have that authority?
Right.
But doesn't the e-file rules, we return for correction meeting, I'm sending it back to you because your document contains sensitive information or PII. But you also,
We're in connection.
yeah,
The redaction needs to come from the filers in.
Yeah.
Which I believe Tyler has provided, but I don't know how many attorneys use it. Is the problem. And so we try to catch it as much as we can, but like with big counties, when you have so many documents coming in every day, you could miss something on page 3. So that's where, or page 67. So that's where the problem lies, and really some education to the bar, I think needs to happen, knowing that this is coming in the future.
Because we
But
have
they're
not
not
started the
now.
business of redacting. That is not what we do. I mean, if the lawyers have decided or have been negligent and just let stuff in, that's what happens. I mean, if the county clerk, I mean, there are a backup, the county or the district clerk or the clerks can, catch it and then send it back. But I don't think in terms of, we'd really have to think hard about us taking a standard where we somehow do redaction. I know it can be done automatically in certain platforms, because it's basically tag the, so many numbers that would be a social security or a driver's license, and all of a sudden it automatically picks that out. A lot of lawyers use those kind of platforms. But I don't know that's necessarily what we want to recommend to counties or.
In the federal system, when lawyers on a case log into a case, they have to acknowledge they're going to do that.
So I like
If they file
that.
any pleading, we may not be filing a pleading, but if you're entering a case, they say, if you're filing a pleading, you have this obligation to redact personal private information. You check the box, then it lets you into the
I
docket.
do like that.
I know, I like that too. So if they're doing that,
That's
Is it
what
mandatory? You get very patient.
what I was gonna say is, what are some of the states that are as advanced or more advanced than us doing on this? And what are we doing in case? And that is a good point. I forgot about that, but
Yeah,
every time you log into Facebook,
Every time.
every time, even if you
Yeah,
checked it before.
I forgot about it.
you have to do. With caveat that it usually the legal assistant or the young associate that's doing it, not the, the lawyer, but.
It brings it to their attention, like,
Right.
hey,
yeah. That would make me feel a lot better if we had something like that. How difficult would it be to do a login type of, when you go into the system and do that? They do it for Pacer.
we have to click the box and then it lets us spend.
It's just like I acknowledge the terms and conditions of using this website.
Yeah. Yeah. No.
The other thing you might consider is whether to suggest to the Supreme Court that perhaps updating the rules so that there is an enforcement mechanism and a discipline mechanism for the attorneys who don't do it or who check the box and then don't complete. Because otherwise you check the box, okay, so what's gonna happen if they check it and then they don't do it.
There's also gonna be outrage in the attorney community if every time they e-file, they have to check that box that says, go get it.
I think it happens should happen on a login, not each time they file,
Yeah.
but each time they log in.
Also, we think about 1% of the filings right now are using the redaction tool that we already have in place. But again, they could have redacted prior to even submitting it to the filing system. But that's about what does it. And we're checking to see if there's an auto redaction feature where automatically everything can get redacted. Now, I can't say that it would catch 100% of the things, but it may help. But I don't have that answer yet.
What about pro se filers?
Oh, boy.
I mean, I realize county and district may not have a lot, but if JPs do eventually go like, are mandated, Because that's the majority of ours are pro se filers. And we do have, for instance, evictions, some they'll put social security number, they'll put everything on there.
Mm-hmm.
Well, keep in mind, a person can publish their own personal identification number. So if it's me as a pro se filer, putting my social security number out there, that's not what we're trying to snag, although maybe they should know you shouldn't do that. It's when they're putting the landlord's social security number.
Well, or if it's the landlord putting the tenants, right, yeah, that's where.
There are also certain kinds of cases in justice court that are redacted, truancy court cases or
Yeah.
redacted.
Okay. So talk to me a little bit about the pro se filing. They're not a court of record. So what happens to all the filings that in JP court, you have all the filings and whatever, and then are they just stored electronically at the local level then? You know?
Well, no matter of public record, they can still go out.
Yeah. No, I just want
And they get recharacterized if they're an appeal.
right?
And the case number changes, and then it becomes a matter of record
Yeah, exactly.
and county courts of law for the most part.
Okay, I was just curious, just what the retention of all of the documents filed in JP court for those that aren't appealed and don't really become of record. What is the retention? Are there different retention policies for those?
It would depend on the.
There
case
are,
type.
yeah, it depends on the case type, but for civil, like ours just stay in our case management system because we're paperless, so everything just stays in there.
Yeah.
We don't have it to where, for civil anyway, we don't have it to where it'll eventually just fall out of the system necessarily.
Okay.
But for criminal, we do save everything, but there is that 5-year confidentiality rule that's in place. So once a case has been dismissed or dispositioned out, after 5 years from that disposition date, we have to lock it down to where it's confidential. And then no one can get it except for very few people by statute.
Okay.
There are also civil cases where there's a judgment, and that judgment goes dormant after 10 years, can be revived with a writ of scire fashion too. And during that period of time, there could be a writ of execution, which would extend it by 10. Absent all that, cases can actually be destroyed.
Yeah.
Both electronically and paper-wise.
Yeah, no, that happens in the district courts and everything else. At some point, those 1940 cases, got destroyed. Or back when it was paper, you just couldn't.
There are some courts and some counties who are thinking they want to build a new warehouse to store some of these old cases.
Yeah.
Why?
Yeah. Well,
If they're dormant or dead, why do you want to even retain them?
So
I don't know. They're very interesting. So
A lot of JPs don't know about these deadlines and when cases go dead.
Right.
So they don't do anything about it. So you got electronic files and case. A lot of paperwork still being retained.
there's far more stuff retained from electronically, kind of like my own computer, right? I mean, stuff that I would have thrown the paper away long ago, it just stacks up, as a file in your computer. So it's very easy to keep a lot of that stuff if you've got it electronically. That's for sure. Okay, so going back to our basically our thoughts about the redaction and everything else and how that is all going. We need someone to think and check into, maybe establish a little working group on the on what it would look like and the possibility of having the same kind of verbiage that Pacer has for accessing documents for our state filing process.
I think we can have that in standards, can we, right?
Do you think that would be a standards issue? Do you want a smaller working group, Bob? What do you think?
Yeah, we could do it in the standards.
Okay,
And probably, Tracy, what we ought to do is make sure that we have some of the standards folks and some of your e-filing folks.
yes.
So that we're not duplicating efforts.
Okay, do you want to try and capture any additional people for your committees now, or any of the people sitting around here or online and ask them to join you, or do you want to wait and kind of contact them on your own?
I think we have enough.
Well, yeah, I think we have enough.
In your
people.
committees? Okay,
Yeah.
all right.
And what Tracy and I can do is get together, figure out a date specifically on this issue.
Yeah.
Identify the folks and get it going.
Well, that's a great idea. I think that's a wonderful idea to go ahead and hopefully then, who knows what lawyers will do, but then I will feel better that we offered every opportunity to those lawyers' clients. I mean, to those lawyers to give them the opportunity to once again review their filings, and if there's something that is confidential, that they handle it. So I think we're doing something good for the bar and for their clients. So do you think you can have something together for us at our next meeting? Bob? Tracy? What do you think? Okay, then I just know whether to put you on the agenda. Okay.
Well, our next meeting is
Yeah.
in June.
Yeah.
So.
So I'm gonna have you report out in the June. Okay, Bob, other standards things from the
That's it.
standards committee, anything else?
That's it.
All right, what's up on our next deal? Let's talk a little bit about our program update on Research Texas. Read from Tyler, want to chat about that? E-file and research, a whole lot of wax. All right.
1 sec, I'll get it shared for you, Adam.
You like talking picture?
Todd, press that.
So our usual opening slide, just to FYI, I'm gonna try to rethink the graph to the left. I think it's really kind of difficult to depict what it actually is. What it's supposed to be is showing you the EFSP filing volume. The maroon color is the state EFSP, and then the one above that, I believe, is ProDoc or one of the other big ones that gets lost. But I'm trying to think of a better way you actually visually see what the data is. Off to the right-hand side, so we are at the just over 1.1 million users that have been accounts that have been created. Of course, not all of them have remained active, but those are the unique accounts we've had created. The average filing volume during this period actually dipped a little bit, but that's obviously because we went through Christmas and New Year, so it's pretty obvious that the volume will dip down as well. But what did bump up was actually we're now processing about 1.32 million funds daily, and that's both court and convenience fees that are being processed. So the amount of funds that are basically changing hands through the system. And the state EFSP dropped a little bit. So we were hovering around 78, 79%. We're now down to about 76%. But again, that typically fluctuates depending whether it's tax season or not. So they may be filing through a different commercial provider for different needs. JP's still just 21 out of the top 22, and we have 8 projects that are going right now. I think we just had Gillespie JP1 just go live earlier this week, so we are still making progress and slowly chewing through those. Okay, the return for correction rates are broadly across the Texas the last few months. Again, you see November, December, we start to get a pretty substantial dip in the filing volume. But the return for correction rate also drops with that as well. We're still well below the national average, but again, Texas is to me, because I've been in it so long, I still think of Texas as new. They're actually one of the older markets and more mature markets out there now. So the longer we see the markets in play, the more and more that return for correction rate drops. I think some of our highest are around like 4 to 5% is a return for correction rate. So. And then the usual slide. So just a quick prologue, if you will. I try to think about the case types we put in a little bit differently. So if you'll notice, some of the filing volume is a little bit lower. Some of those cases are a little bit new. I try to capture a bit more of the thinking of the impact. So typically what we see up here is debt collection, debt contract cases, because those make up about 30 to 40% of the total filing volume. So obviously those are going to have the most return for correction just by sheer volume. So I try to think about this a little bit differently. Essentially, what's the more impactful cases in terms of it's a high enough volume that it still moves the needle, but there's as you can see, there's somewhere between 10 to 22% return for correction rate on those. So trying to think about differently, if we're trying to solve some of the problems, maybe we need to look at some of the cases that tend to come back the most, not just by sheer volume, but maybe there's something broken in the process, or some way to provide more guidance to filers or attorneys that can help with this.
Can you go back to that slide? Because I can't read it, so I can't see it from here. And I know you sent it, but.
Highest number is other civil, divorce with children, and letters testamentary.
So there's three categories. I'm sorry, John. Yeah, there are three categories for divorce with children, other parent child, and divorce without children that constitute 10.56, 12.75, and 13% error for correction on all filings.
Yeah. The one that kind of jumped out to me was protective order. That's the one that to me seemed pretty concerning, that you've got protective orders coming and they're getting returned at about a 14% clip, just because of the sensitive nature of the case type. So again, trying to capture a little bit different data, a little bit different look.
So are you able to capture on those return for correction if they're actually submitted by an attorney, or are there pro se people who are bold enough to use e-file?
Yeah, we can break that down. I don't have that here, but I've got the data compiled, so it'd be pretty easy to run that through like Copilot or ChatGPT or something to kind of break out those numbers.
Well, by percentage, the occupational driver's licenses, 1 out of every 5 are being returned.
Yep.
And over on your justice courts, repair and remedy, over half of them are being returned. And then tow hearings, those seems to be the kind, you know better than I would probably have the highest level of pro se's, just kind of the nature of it.
I think it also represents, if you're kind of connecting the dot of all the different parts of the system, this may be good data to feed into what are some things that we need to address through guide and file, or some of those guided interviews that can help drop this rate down as well.
And I don't know if it's the same, but when I sat on the bench and when I go into presiding, occupational driver's licenses are almost exclusively pro se.
Yeah.
And
That's why
you'll get them with where they basically have the case style and it's like Iowa or something. Because they've gotten a form and they don't understand the significance of all the caption of a case or anything. And so I can see how the occupational driver's license would be so high because so many of those are pro se.
Yeah,
and usually they try and catch them and help them actually at the district court level and try and get them the right form. But I don't know, I could see that.
Well, the issue, there's a lot of requirements in those occupational driver's license filings that they don't complete. They're left blank, and so they get rejected because they're an incomplete filing.
Yeah.
I've done lots of occupational driver's license.
So just breaking out the return for correction rates by reason, this is a slide we kept on here. As usual, the biggest ones are the judge's requests, filer's requests, and incomplete info. Off to the right-hand side, those are sort of the historical norms. Filer's requests, since its peak in 2022, is actually down almost 10%. So that's pretty good. One thing I notice a lot in the filer's request, if I actually started to scan through the comments, I will say a lot of the clerks are really good about just, hey, I'm gonna give you a call and help walk you through this. I'm gonna reject this and give you a call and kind of walk through it together. So I see a lot of comments like that in there, so that's encouraging.
Okay.
But that's not a request by the judge. That was a clerk.
Yeah. Oh,
That's the,
We
No,
wouldn't
I'm
even
fine
know
with
about it.
this. Yeah, the judges request a lot of those, like standing orders being
I
missed,
think
things
it's
like
all the
that.
standing orders that they're not supposed to have, but they do.
Yep.
So,
I think the filer's request going down too is, I know we've talked about this a lot, that was being misused by clerks' offices for rejecting things, because I had it happen to me a couple times. I said, I never requested that this be rejected.
right, no, I know,
But it ain't anyone else that they just hit on this request, so
Right.
hopefully it's the product of education.
Yeah. The guide and file, so the usual 46 interviews, 8 are currently integrated. There's actually a list out there that we've compiled, and I don't mind resending it because I know there's been some regime change that details a little bit more why some of the interviews weren't integrated, and could be something to kind of dig our teeth into, say, is there some low hanging fruit out there? Funny mention occupational license, the notes that Neela, one of our in-house attorneys, if you will, turned product owner that helped build a lot of these in the beginning, said occupational license is like one of the most difficult to actually do, be a guide file. So that one may be kind of pie in the sky vision, maybe something we could eventually get to, but there are some things out there like maybe updating the forms to something more recent.
yeah, maybe
That
so.
could be, again, just low hanging fruit. Nice thing is that we're starting to see a increase in the completion rate. We had a pretty big jump in 2025, and so far in the first 3 months of 2026, we're seeing that start to steadily increase. So it's basically pro se filers going in, starting the process, and instead of abandoning it halfway through, which we do capture that as well, they actually complete the form. Whether they print it out and bring it up to the counter, or they e-file it, is represented over to the column to the right. But okay. And this is similar to the other slide, is the return rate specifically for guide and file. So it's kind of all over the board, but the steady average is around 17.65%, which the little percentage drop, that means since we passed JCIT standards version 10, where basically that blurb in there says if it's a guide and file and a Supreme Court form, you have to accept it. So we've actually started to see the rejection rates come down since the peak, or since that happened. So. And then the integration mandate, we are 82% overall complete. We've got a lot of them are still the third-party vendors kind of working their way through. We have some vendors that are kind of flip-flopping between the integration types. They seem to want to, well, for good reason. There are some that were like, well, I'm just going to integrate with research directly with my county. Then they rethink, it's like, well, let's go ahead and integrate with the EFM as well. So that way the county has the most value in the system, which I tend to agree with. So that's why I think some of the vendors are dragging their feet a little bit. Tyler ourselves, we've got 3 counties left. That's, well, 2.5. Winkler County Clerks, Kerr CCDC, and Angelina County, which just completed a SAS flip. So we're engaged with all of them and expect them to hopefully be going live here in the next 4 to 6 weeks. And then the flight 3, which is the last flight of the counties, we're about 80% of the way there.
Okay, any questions? Questions? All right, no, that sounds good. Glad to see it.
Just refresh it. You say you have PowerPoint?
Yeah.
Yeah, I do.
Okay, Judge Ridgway has a PowerPoint for his presentation.
You mean we're not at the end of the meeting?
Huh? No, I'm gonna stick you right in here. You've had to wait and have been very patient.
Well, thank you. What I want to say, if I can get my come up, you can probably, Frank, bring it up, is I kind of look at the population of the state of Texas and where are we doing a really good job on e-filing and in terms of the population of the state. And what I've found, and you can scroll down, I guess, a little bit on that.
Next.
Next slide.
Yeah. So, and I can't even read my own because my computer went to sleep. Basically what I want to say is our state, we have almost 87% of the state's population is in 51 counties. And so you would want to hope that we would get e-filing in all of those 51 counties. But we don't. Okay, and so we've identified for those counties that are filing, they rip in all courts in all counties, almost 75% of the population of the state are e-filing. And those that are of the 51 largest in all counties, but it's not all counties. So we also have a number of counties where they're filing in some courts, but not others. And I'm going to come back and address that a little bit more, but those represent about, if I could read my own writing up there, get it to come up. Give me a moment, because I can do this, see it on my own computer better. Okay, so 86.7% is in 51 counties. The next 203 counties represents 13% of the state's population. Okay, of the 51 counties, 23 million across 26 counties are currently filing in all JP courts. And that represents about 74% of the state's population. So I want to suggest at least for all those courts and counties that are e-filing, we're doing a really good job capturing a large part. We have another 7 counties that are partially filing, but not in all courts. And 60% of the courts in 7 counties, or about 24 counties and about 40 courts, some of them are filing, but not all. And I think that's an area we as a committee would like to work further on. Another 7 counties among the 51 largest are not e-filing at all. And it's 31 courts and represents a population of about 1.1 million people. The 7 counties where they're partially filing represents another 2.58 million people. So if we get all of those 51 largest counties, we're going to capture a very significant part of the state population. And I get my suggestion is out of that, let's not mandate e-filing because we're already getting as a percentage based upon population and the courts in those counties, we're already doing a really good job. So what's the next steps? And I've worked with Evan in the past and Jess. I think we want to verify the court data that we have, and both with OCA and with Tyler, to make sure we've got all the data. I saw some things in the data that we do have that don't look right to me.
Okay.
Okay. An example is Galveston County. It shows there's 9 courts. Well, there's only 4. They eliminated 5 JP courts in Galveston County some years ago. So I'm want to make sure that we've got the correct data in the databases that we're using. The second part is the secure current contact information for each of 14 counties that are either partially filing or not filing at all. That represents about 55 courts. And we want to know why they're not filing. And in some cases, it may be things like Commissioner's Court will give us some money to be able to use a technology that is available, but the county has chosen not to support that. It could be a technology issue in terms of the computers required to make it work. It could be a resource. It could be people may not have qualified or enough people to be able to use the system. And so they've been slow to do that. We don't know the answers. Okay. I've prepared, I'm not gonna share this with you today, prepared a list of all the questions I think we need to ask.
Okay.
And find out the reasons and then report that back to you and find out what we learned from all those questions. But we have to have good contact information to do that.
So it sounds like to me you need to talk to both the JPs and their offices as well as, you know, Tyler to probably get the updated data for.
Yeah, and to some degree OCA as well. All right, and then I would propose, based upon all that, that we prepare a report based upon what we find from the result of all those interviews.
So I'm just curious. Okay, so we have a county where, you know, half the JPs are up and running and doing a lot of work. And one of the in the most populous county, one of the most populous counties that you were talking about, and that. So in that case, the commissioners may have given some of the JPs resources. Is it more that the other JPs
I don't
want, or that's the kind of information you're going to find out?
I don't think that's happening, but my base is Harris County, and I don't think they discriminated across the courts giving and all courts in Harris County, because we had a court manager.
Yeah.
In the past, who was a driver for us, they get to this point in the first place. Most county, in fact, virtually no other county has a coordinated person or department that is looking to make sure that all courts within that county are doing the same thing.
So JPs just may decide this is not what they want for the county. They don't want.
I don't know. I don't know if
that's
it's
what you're going to be finding out with this. Yeah.
Maybe they didn't decide, maybe they just brought it up, never thought of it.
Yeah.
You know, it could just be inertia.
God, it would be hard in a county where you've got, you know, the large population that they have where, you know, it looks like a great number of filings maybe take place that you wouldn't at some point think, maybe we ought to automate this. And, yeah, but I agree with you. Who knows?
Let me give you examples of the counties, partial counties. I wanted to target 7 of them that are partial filing, and here's the counties: Hidalgo, Brazoria, Galveston, McLennan, Webb, Ector, and Grayson. Okay, and in McLennan County, we know that by the third quarter of this year, they're going to be doing a lot better on e-filing than they have in the past. Only because I know people in McLennan County. Okay, the 7 counties that aren't filing. Oh, by the way, those counties I just mentioned in terms of population rank in the state, Hidalgo is the 9th largest county, Brazoria is 14th, Galveston 16th, McLennan 20th, Webb 21, Ector 32, Grayson 33. So they're still large counties, and those counties represent about 2.5 million people. Okay, the counties not filing at all amongst the largest are Ellis, Comal, Midland, Wichita, Liberty, Potter, Angelina. And that's another 1 million people across about 31 courts.
Ellis and Kamal, I mean, those are.
Kamal actually has an active project right now.
I was going to say, they are big.
Yeah, they've got an active project with the JPs right now.
Okay.
Comal's the 27th largest county with a population of about 212,000 people.
Yeah, no, I just wondered. Okay.
So I think if we get these plus a few other courts that are already filing, we've got about 60 counties that are e-filing at this point. If we can demonstrate progress with these counties, we're gonna be close to 90% of state population. What I know in the small counties, a clerk who used to work for me and has been working for the constable's office, just was elected, will be taking office in Austin County, Sealy, Texas, because has no opponent in the November election. It's a part-time job. There's no clerks. It's just the judge. And in a lot of small counties, it's a part-time job. And it's a judge and maybe one or two clerks. Are they ever going to get to the point of being able to e-file? I think not. And the volume and the cost benefit analysis of trying to get to that point is probably not there.
And I think part of the problem too could be is, you know, when you file with district or county, you know, you're filing with the clerk's office,
Yes.
correct? So it's just one, you know, set of parameters, whereas with the JPs, you could have, you know, precinct 1 in this county that does one thing, precinct 4 in the same county that does something completely different. They could both, I've heard of situations where the same county, different precincts are using 2 different case management systems because they don't want, I mean, so it's, I could see how that could be part of the problem as well. Or you have the ones that just physically lack that paper and want to do nothing electronic.
Wow.
You know, those still exist too.
Yeah, absolutely.
Not only that, in Dallas County, we actually have JPs that occupy the same courthouse and do 2 separate things.
Yeah.
One partially automated, another absolutely not.
Wow. Okay.
Anyway.
That's above our pay scale to manage that, enforce people
Judge Ridgway was
to do
talking, and there was a discussion about, you know, JPs are kind of like in silos, and each one in every county, they're doing the same thing. That was kind of the Dallas County was the same way. We actually got kind of a business coordinator to kind of coordinate all of that. And 3 years ago or so, we moved from our just standard paper with the DOS AS400 mainframe function to enterprise justice that helped with kind of consolidating or standardized business processes, because they're still they're in a paper environment, not wanting to use e-file, which goes to what Judge Ridgway is saying. If you get that, then you can have a standardized process, because in the case management system, it's this way only. They're not going to design it or based on a court's need. But
meanwhile, we have Jess, who for Collin County makes sure that it all happens right.
That's right.
So it doesn't have to be a JP. It could be someone else, but it has to be a person who has enough cloud technical skills, whatever, to be able to manage, you know, and set the expectations for all the JP courts in that county.
And part of it too could be who has the ability to manage it, because I actually met with Wichita County a few weeks ago. Their IT department is who deals with everything configuration wise for JPs. JPs don't necessarily, a lot of them don't necessarily have a dedicated person to focus only on their stuff. There are very few counties that have very few that have that.
Oh, I would bet you get all kinds of strange configurations and everything else, depending on who your JP is. And, maybe their kids want to help.
Well, it's true. And, you know, you've got, I know whenever my position was originally created, so for those that don't know, I manage all the JP configuration for Collin County, and I'm JP specific. That's all I do. I work for all of them. So whenever I first got into my job, different people, too many people, had the ability to add offense codes. So we had multiple ones for no insurance. I mean, it's all the same thing. So I could see how that could be an issue too when it comes to e-filing. Because I know when we went in to do e-filing and configure it, it was having to say, okay, look, we're all going to use this one thing of debt claim, small claim.
Okay.
We're not going to
have
have
standardized process or whatever.
Yes, because JPs have the ability to just kind of do what they want, as opposed to when you're filing in district or county.
so are all of your JPs on enterprise justice?
Yes, sir.
So how did you and you guys went, they moved to enterprise justice what year?
2009.
So what do they do for 2008, 2007 cases?
We did, whenever we went to, sorry, I still call it Odyssey, so forgive me if I still call it that, but when we.
I do too. So.
Yeah, okay, good. We did conversion, and so, because we had AS400 green screen, and so what we did is anything that was still an open case, we did a conversion and moved it over to Odyssey. I'm not exactly sure on the back end of what happened. There were issues with that. We still to this day find some cases that were messed up from it, but.
So there was a big data cleanup before you went live?
Yes, sir.
Okay.
Yes, there was.
Our court was the largest pilot court ever with Tyler to do this migration from our homegrown system to their system. But your point about being in a mainframe versus in a client server environment it blows me away. Anyone's still on the mainframe systems because they're antiquated and very difficult. In fact, one of the reasons we had to go outside is we couldn't find one to support the code system that was used to build our own system.
Yeah.
There's no one out there that uses that same code.
So Ed Wells has his hand up at this time. Ed, do you have something to say?
Yeah, I just was gonna comment that, Harris County is one of those few counties that do have resources dedicated to the justice courts and configuration and maintenance for enterprise justice. And we have one instance of enterprise justice or Odyssey for Harris County JPs, 16 JPs in our counties that have about 500,000 cases a year. But here's the reality. We have one configuration for all 16. On any given day, there are probably 25 different ways for those same courts to do things because they, at every point, are pushing to do things differently. We have JP courts that are 8,000 cases filed annually. We have JP courts that are 100,000 plus filed annually. They're staffed differently based on those, but even that is not exact. And I say that because it makes it very difficult for us to manage that. And I can only imagine in the counties where they either each have their own instance or the courts operate so independently, how difficult that is with no one dedicated to them for that configuration, maintenance, recommendations. We have business analysts dedicated to the JPs that manage the configuration. And that's more than a full-time job for more than one person. And so I recognize the issues with the justice courts statewide, and we're gonna, as we look at doing things to try to help bring more consistency across them, the differences in resources, the historical norm and culture of that independence. They each operate as their own department in most places. And so they have their own budget, their own clerk's office, everything as a silo, as someone mentioned. It makes those challenges much more difficult. And so as we're doing this, I think the best thing that JCIT can do and counties can do is make it as easy as possible for courts to do the right thing, the easy thing, because people will gravitate toward that over time, all the while encouraging them and educating them on why it's important. What does this improve? How does this impact the people that come before the court that are in your community, right? Because the JPs touch the community more than any other court division probably statewide. And that's not an easy task. But with how many JPs do we have statewide? I don't even know the number, frankly. But it's a large number given that every county or most have a minimum of 4, right? So
795 to 803, based upon the data that I can see from,
Okay.
is how many courts we're looking at.
And so based on my experience in Harris County and those numbers, there's 1,000 different ways to do this, right?
Yeah.
And so that's a tough undertaking.
To give you a sense of all this, precinct 5 and precinct 4 in Harris County, the population of each of those precincts is larger than all but 3 other counties in the state. So if you take precinct 5, there's only 3 other counties that are bigger than just our precinct. And the same, and precinct 4 is the same, and both of them are still growing.
Justice Hawkins?
I don't want to interrupt, but just want to let everyone know, I've got a family commitment I couldn't move, and so I have to actually get up and leave now. I appreciate you welcoming me here today. I'm not storming out because I'm upset about the conversation.
You can get hot about those JP awards.
I apologize. I'm
Sorry to
sorry.
be leaving early, but thank you for welcoming me here today, and I look forward to working with all of you.
All right, thank you. Thank you so much for coming. We hope to see you again soon.
And welcome back.
Thank you.
All right, so it sounds like, Russ, you'll be reporting back to us. You're gonna do that investigation, perhaps talking to JPs themselves and trying to figure out what is it that you have, you know, kind of set the table of like, what is the current state? And then where do we want to get everybody to, or where can we encourage them to go and what we can do about it? So that's kind of a big lift for you, but you have some other people helping you, correct?
Well, just talk about and see what, first to make sure we got good data, and then make sure we're okay with the questions we want to ask, so we're consistent across all of our interviewing process. You know, an example, Hidalgo County, from what I could see, has 9 JP courts and 8 of them are e-filing. So that was kind of number 1 on my list.
Yeah, no, we look forward to.
Brazoria County has 7 JP courts, 6 of them not e-filing. So those are, so I've tried to identify those counties where we would have the greatest impact and look at just 7 counties on partials. And after we got a good handle on that, then to look at about 7 more. And again, these are among the 51 largest counties, why there aren't e-filing at all.
Yeah, no, I think that's a really good question to ask. And then that way we will all know, okay, so is it lack of capability, lack of whatever. And so we can kind of do that. So we'll trust you and your group to go and research that and report back to us in June at our next meeting. That's okay.
Yeah.
All right, with that, our next.
Okay, my committee update.
Yeah, no, okay. Yeah. Hold on 1 second.
Before we go on, earlier when we were talking about redaction, I said that I thought the system had the ability to auto redact. So as y'all are kind of working through that, it does. It's just a configuration. So every filing can be redacted through the redaction tool within the EFM. So just as y'all are talking about criminal or in your subcommittees, just know that that is something that the OCA has already paid for.
Yeah.
It's just a configuration. So if that's something y'all want to turn on, we can do that.
Okay. That's what, okay. Thank you for the reminder. Yeah, thanks. All right, yes, Tracy.
So for the e-filing document access subcommittee, we did discuss at the last meeting about the daily summary of the e-notices that Tyler was working on. That didn't get rolled out in February, but they're looking to get that rolled out mid to late April. And then attorneys will get a summary of all those e-notices from Research Texas. We also discussed in the subcommittee that the e-file only and e-file serve discussion that we've been discussing in the last meetings, that per the mandate and rules, statutes and states that attorneys must electronically serve other attorneys on the case. So if they're not doing that, then attorneys just have to bring that up to their judges Because I don't think there's nothing that we
Right.
need to do at a state level. So that kind of discontinued that discussion, and then we discussed the removal of attorneys on e-notices, because that was near and dear to some of our committee members' heart. So we did find that if you're an integrated county, so those integration counties, which I believe were a lot, it was close to 200, I think, at the time. The only way that attorney notice is if that county CMS sends those parties and sends those attorneys that are representing the parties on the case. Then they'll get a notice that an order is signed in their case or some filings happen and that sort of thing. So all the CMSs should have the proper data for the attorney of record on the cases. So attorneys that are not on the case should not be getting notices. But as you know, through e-filing, if you're a non-integrated and they add you to that e-service contact list, you could be looking like a party in the case and potentially getting a notice.
Yeah.
So, but only attorneys will get the notice right now from the integrated counties. So I don't think that will be an issue at this point. If Tyler turns on or has integrations for non-integrated counties, then we may have to look at it. But right now, if only notices are going out to the integrated counties, then I think.
What about pro se's, where there are no attorneys?
Pro se's will be the next thing that we're gonna tackle in our subcommittee to see how they could get notices. But right now, only attorneys are getting them.
Okay, so they get notices just sent out from the district clerk.
Correct.
Pursuant
The
to
district clerk has to continue
Has to
their
basically
their
continue
normal
their
process
normal processes.
through postcards or mail or email,
Yeah.
however they have it set up in their county. So that is one thing that a lot of the clerks do want us to focus on, because they want Research Texas to handle that notification to the pro se. But we've got to figure out how that's all going to work.
And you also have, at that point, you have other, constitutional issues and things that may arise in terms of dealing with pro se's. That's always difficult. To make sure you understand where they're supposed to get notice and that sort of thing, and what was it adequate if they don't have a phone, they don't have a computer, they don't have a steady address, as some of them
Right.
do, what you do with that.
For us, we have a optional thing for pro se's to sign up to get noticed electronically.
Where they voluntarily.
Where they volunteer to sign it up.
Yeah.
I know if they do file something and in their signature line include an email address, some clerks could do it that way.
Yeah.
But it's all that we're gonna have to discuss
Big
and try to
discussion.
figure out.
Okay.
So I don't think there's gonna be a lot of people saying, hey, I'm getting too many notices. I don't think that's happening today, but it may happen in the future, and that's something that we have to look at as we continue down that path. And of course, we continue our discussion to where, do we allow attorneys to remove themselves or not, and do it the proper way, which is filing the motion withdrawal, that sort of thing. But I do know, speaking at the winter conference, that a lot of the clerks, especially in family cases, or I guess it's all cases, they're not inactivating those parties until 30 days after the judgment. Because that's the time period for appeals. And so they will inactivate the attorneys 30 days after that case is dismissed. So they are working that into Odyssey, if they have Odyssey, Integrated Justice.
So the family law cases are doing that?
Yes, they'll put in a 30-day date before they dismiss the parties in the case. And that's built into the case management system for most counties. I know we're building that in our programming logic as well.
But that's just for family cases and not like criminal cases.
Correct.
not family civil cases.
Right now, criminal cases are not in research, they're not in the notice part that I know of in research.
No.
You're correct, yes. So we haven't gotten to that part yet.
Can you have another question?
Not on this, but there are a couple other things I was hoping we could talk about.
Okay.
And then I think Laura's comment about missing documents in Research Texas. I'm not sure if she got with Tyler, but we'll discuss that in our next meetings as well. So that's kind of what we tackled this time around.
All right, Dan.
One, I think I missed a couple meetings, so this may just show my ignorance. Where are we in the process of electronic distribution of orders?
I just looked at my notes. We discussed that last meeting on the electronic distribution of orders.
So that's what I was just talking about with integrated counties that are integrated with Research Texas, which there's the Supreme Court ordered that integration. And so a majority of the counties are already on, but when they're integrated and they send that order up through that integration, that's when the attorney gets the notice.
Okay, but are we doing this stage process where it's going to be certain counties and like we did with e-filing in the
Top 10, top 10 went first. And
so, I mean, how many county, are you saying there are 200 counties now that orders are being
I don't
distributed?
know how many. There was over 200.
Do you know, Evan, do you know how many counties have integrated now?
I have to double check the law numbers. It's well north of. I think there's
There's a ton, right?
There's only like 60 something left to.
Okay. The vast.
I think the smaller counties are the only ones.
60 offices, so it's only like 30.
Is Harris County one of them that is not getting orders?
No.
And I mean, I'm not an attorney, but for instance, when a court appoints me as an
that's
mediator or
the
something,
different,
but that's an order.
It's an order, but
Only attorneys are getting.
But right now, they program for attorneys. We need to now address if you're a visiting judge. Is that what you're talking about? Are
Well,
you a
not just visiting judge, but if you're the attorney ad litem that's appointed by.
Well, that should be, you should be, attorney ad litem should be designated in the case file, yeah.
Well, but I do get, the clerks enter me in the participants in Harris County, but as a mediator or as for our guardians ad litem. When the order appointing, because it's been this way for years, it's not Tracy's fault, but it'll be months that go by. I've been appointed to something, nobody.
That's a good.
And so, ideally the orders, whatever the order is, should be going to relevant people who need to have notice of it. And that can be pro se parties, to be the lead attorney on the case.
Be the ad litem. I'm just trying to think who.
Attorneys ad litem, guardians ad litem, special commissioners, in eminent domain cases, all the different type, special masters. If you've appointed a new trustee, and then you got the, amicuses and family court. And so, we probably would want to see how thoroughly.
Can we work with Tracy to kind of start talking about those? We've kind of got the main attorneys and parties, I guess, down.
Yeah.
What are we going to do about all these additional appointees or designated people that are part of that case and special roles?
Yeah.
So I think that's a really good point, and that would be something to really look at. And maybe what we could do is get together a list that then can go to Tyler of, or somehow get some of this program.
Mm-hmm. Yeah, not happy. Worked with Tracy before, happy.
Oh, yes.
Yeah. So that's great. So I'm going to put you then on that subcommittee, Dan, to kind of look at additional recipients of court orders.
It may have to be something, Bob, that we have to look at in the standards as well.
Okay.
Because I'm sure with all of the configurations that we have out there right now in the technology standards, we only focused on case types and filing codes. There is no party standards. So I can call something a guardian ad litem, but some other county might call it something different.
Just ad litem.
Well,
Yeah,
people
it's
use
ad litem
litem
or
in
the.
two different
Right,
flavors
exactly.
and very different responsibilities. And then you've got just guardians
Yeah.
appointed by the probate
Right.
courts, you know,
Right.
so.
So that would make it harder on Tyler
Right.
to figure that out statewide, because
Correct.
I'm sure there's umpteen million party types, just like there were case types and filing codes before we standardized.
And I don't know if every case management system even allows special parties outside. It's very easy to see that here's the party and here is their attorney.
Yeah.
But then when you start talking about all these special parties, is what we call them.
Yeah. I don't know what
Quite
that
as easy.
process is. Yeah.
And
in
not all
terms
case
of-
management systems may even allow those to be entered in, so.
So there's a big problem with bondsmen not getting those when a judge modifies conditions of bond, when someone go out of state.
Right,
And
I
things
mean,
like
that's
that.
more,
Yeah.
that's more,
Some more.
party types.
Yeah.
Tracy, is it just the notice that they get, or is it the notice with the order attached?
from Research Texas, I think there's a link to the order.
So if the notice went out to everybody that they had an email, and then you'd go to the link, and if you weren't one of the people that had some sort of special access, then at least they would know that an order had been entered. I mean, if there's no risk of some order that shouldn't be exposed going to a person, they've just got to notice that there's been some action and.
Orders really can't be sealed.
Yeah.
Right,
You know,
but-
so those should
Which is
be.
I guess an adoption in certain kind of.
But
Yeah, okay,
Yeah, I mean.
I'm thinking.
Right.
Yeah.
But I was thinking on e-file, like, we don't allow certain users to access certain civil types of cases. So if it was in one of those, a bunch of attorneys could get it, but maybe not a non-attorney. I don't know. I just think everybody should be able to get the notice for sure.
Well, it's not, my issue isn't about being able to see the order. It's the distribution of the order. That, you know, making sure that, yes, we are now electronically distributing orders so that when.
So they're timely, so that it's not like, oh, I went on vacation and then all of a sudden orders went out and he never even saw them, you know?
Or, you know, so how many times, hundreds, thousands of times, I'd sign an order, it's in the case file, and the lawyers just never bothered because they just get the little postcard, you know, that an order's been entered on the motion for summary judgment. And I'm like, you know, I took some time to actually write this out. Would you read it? You know? So being able to say that, yes, it was sent to you. If you didn't read it, that's on you rather than the old school. So that was the first topic. If we're done talking about that, the second.
Yeah.
And it occurred to me, we were talking about these, the guided interviews and so forth. And it may be too late. We got to get ahead of AI on this stuff. In my arbitration, I'm seeing stuff that's obviously written by generative AI, especially with self-represented parties. There's different issues with lawyers and the ethical problems with that. We should probably be talking about that as well. But, you know, the forms and stuff like that, like I said, maybe too late. The form stuff, the briefs, the motions, so much of it now, people are going to ChatGPT or Gemini or whatever the flavor of the month is. And they think it's right and it's not.
But for most pro se's, okay, I'm gonna be ugly, and it's also from my teaching at law school, which I do, and have done for 40 years. AI kind of helps. I mean, frankly, from an elusive, a pro se who doesn't understand the law or anything else, at least it's coherent in terms of sentence structure. You know, it may be totally wrong, and it's up to the judge, whoever gets it, right? But I mean, even my law students sometimes are not the best writers. Now, what they do is they obviously look at it or whatever, and they're not supposed to, they're absolutely prohibited from using AI. But if you've seen it enough sometimes, you know, when the student at the very beginning of the course could barely write coherent sentences, and then all of a sudden there's, you know, whole paragraphs of lovely stuff. It's, But anyway, I agree, there's a chance that the pro se is putting forward all kinds of incorrect stuff, but if they're pro se, you as a judge, definitely checking all that
We
stuff.
just saw the stats. What was it, half of the repair and amenities are returned for correction?
Right.
You know,
So maybe
one in
they
five-
could,
one in five of the occupational driver's license. And so at least on the stuff where we know it's coming in wrong, maybe those are things that we should make sure we're getting the guidance file and all that stuff up to speed on.
oh, that it incorporates AI.
I'm not saying incorporate it, just there are areas where AI is going to be used where it's coming in wrong and stuff's getting rejected. So
I think it's coming in, I think that probably if they went to guide and file and they just said, this is the rule or something in Texas, it will go there. We ought to play, I would play with that. I'll just check and see, but if it would work, yes.
So I forgot to mention on my way down here, I actually I just have the raw data from some of the return for correction reasons in Guide and File. I fed it through Copilot and it asked a couple different questions. And it gave me a pretty detailed breakdown of within these case types, like your eviction case types, what are like the most common things we're seeing? And a lot of it's like, you know, missing required forms, stuff like that. So I have a more detailed breakdown.
Oh, that might be good for us to look at.
Yeah, I was actually have a side note that I was gonna send the analysis back to Frank and he can distribute to
Oh, perfect.
whoever's interested. And even in that, there's some recommendations on like that, of course, AI generated it. Sorry.
Yeah.
It was like, hey, based on all these things we're seeing, here's some things you could think about doing. And those are like a checklist cover form for a post. Just do you have, you know, military affidavit filled out, things like that, just very simple things.
Yeah.
So
I guess that's where I'm going. I didn't.
Yeah, no, I'm just used to people saying, oh, don't let those students use it. And I'm just like, you know.
No, if we don't, especially the areas where we've identified there's a really high error. If we don't have something available, they're gonna go to AI and it's gonna be wrong.
Oh,
And so,
But isn't it, I'm sorry, let me, Casey has his hand up, but I just have to say this. Isn't that just trading one hallucination for another?
absolutely, that's what I'm saying. That's great.
I'm not talking about us using AI. I'm saying we've got, for some of these cases, we've got forms already, or we've got the interview process already. We've identified, as we showed before, at least 3 areas where we probably need to do some targeted work so that they go through that process instead of going to some external editor where it's gonna, you know, that's what I'm suggesting. On the attorney side, a lot of the federal courts now are requiring certifications that you have checked your sites, or that if you need to certify whether you used AI or not. Perhaps we need to see if the Supreme Court wants us to explore.
I hope they don't do that. I am telling you, after being on the appellate bench, I don't know about you, I could say, in terms of lawyers, they are bound and they ought to be looking at, but what they're using, what I see them using it for, they take their crummy writing with their correct sites and everything else, and they load it into ChatGPT and say, can you clean this up? And it cleans it up. I'm telling you, I'm just saying. I mean, I that's what I have seen lawyers do and students do, and it doesn't take what, you know what I mean? It doesn't take what they've done, and all of a sudden they've got some new site in there. They know enough that is not what they put in there.
That's great, if that's the biggest.
Yeah.
I mean,
But I think
it needs to be done by now. We're
just putting
still
it as
seeing
a
weekly
prompt of
in the ABA
Draft
journal,
me a brief.
this lawyer submitted
Yeah, they
briefs
did.
with hallucinations.
Right.
And some of them are offenders. After they got sanctioned, they kept doing it.
No offense, go to Westlaw sometime and start really working in there and their little AI thing, and it creates all kinds of crap, I'm telling you. But you've got to have the sense to know what you use it for. For poor writers, not using it for their research, not using it for whatever, but to have ChatGPT clean it up, it makes it more readable. That's all I can say. Go ahead.
I was going to say, Judge, AI it's like a chainsaw, right?
Yeah.
Works great when you use it right, but it can go horribly wrong if you use it wrong.
Absolutely.
But I do think, to Judge Hines' point, there's 2 tracks that are going on. As people quit using AI as a search engine, start giving it more and more context to say, like, I'm in Harris County, I'm in Texas, or give it more context, the response will get better. And so as people start learning how to use the AI properly, that'll get better that way. At the same time, the tools are getting better and better. I mean, you've got Copilot, Gemini, Claude's jumping ahead, Perplexity's out there. So that we're still in the infancy of it, but it's getting better and better and better and better all the time.
Yeah, I was just going to jump in with the law firm perspective as well. Like, we are seeing an incredible jump in usage from all of our attorneys. And it started as you described it, Judge, but then it is now transitioning into the better tools are resulting in the better product, right? So in addition to just the enterprise-wide tools of like ChatGPT or Copilot, we're also now seeing the Harvey tools, the Legora, the other tools that are designed and built for legal that most of the attorneys may have access to, but not a lot of the pro se folks are going to have access to. So but I think that goes back to Casey's comment, like even the baseline public tools are continuing to improve. I don't think we can avoid this. They're going to use it one way or another. And so I can't remember who said we've got to get ahead of it somehow. That is absolutely true.
Yeah, I think that, actually, I think that we ought to embrace in some part and see if we cannot in some of these use those tools to assist us in developing easier forms for pro ses. Things that could work well with pro ses. I think that would be really beneficial for that level. But you craft a very narrow path for it. In other words, and so it's not hallucinating and throwing in. I mean, it's pretty amusing what it will throw in stuff. So I think that's a real thought. Actually, I'm not the one to do that, but I think that would be a very interesting path to take, is to really help and boost the ability to use those pro se tools. Because I still think even though they're using them, they're getting highly rejected. So.
What would you like to see there?
Yeah, I mean, that would be a specific craft of a tool.
Well, yeah, I don't have any issue with finding a way to integrate AI. It's coming.
Yeah, that's what I mean.
I'm not the kid putting my finger in the dike or anything. I just think we do need to start thinking in terms of, okay, how can we guide people away from the pitfalls of AI?
Yeah.
So that understanding that a lot of the pro ses, for instance, are going to be using AI to write their stuff. So how can we adapt so that that is a net productive circumstance and help guide people away from those pitfalls?
It's interesting. Some of those, the divorce one that's a hard, if you've ever gone on the guide and file thing and you're a divorce with children and all that, to get all that together for a pro se is difficult ask, and you go through the form, what they're asked to fill in and how they're asked to fill it in and that sort of thing. So I'm just wondering if you couldn't improve those guide and file forms to make it so much easier for, someone that maybe has a hard time comprehending, complicated English or legal terminology.
Well, and as a very early step, one of the best ways to improve on an AI prompt is to give it good information to start with. So if you say, hey, if you're trying to fill this out, download these things and put it in your AI tool of choice as your base documents, and then ask for help filling it out. And like that, if you give it a substantive piece of information to build off of, rather than them just typing in, how do I fill this out with nothing, then that helps get a better quality of answer.
So these are great ideas.
Yeah.
And I do not have any issue. I think it's great you use Copilot to parse your information. I'm not suggesting we shouldn't be finding ways to use the productivity of AI to improving what we do. I just let it off. Like, we've got to start, integrating AI and the effect it's having and what we're doing here.
Yeah, so why don't we, since you mentioned it, tag your
I knew this was
Way
gonna.
to go, Dan. I'm so glad you have just jumped into the fray. You know, you missed a few meetings, but now you're just right back in the mix.
Justice Simmons, I was going to say, as one who's overseeing kind of guide and file anyway, we're happy to incorporate any of that as part of that if you'd like us to look at it.
Perfect. Yes.
My goal will be to
Okay.
make the process
Just as
easier to walk us through it, not to change what we're doing on the data and guide and file. Because we've only got, I think, everyone was reporting a while ago, we've only got 40% of the process being completed right now by people who are actually filling out the forms. So
Okay, who else wants to be in this project? I'm looking at you. You're a giant person on our screen. Are you in? Okay, all right, thank you.
Sure.
All right, anyone else want to join Tracy? Anyone wants to join? Awesome. Okay, two more. Great, we've got, okay, it's our whole group basically. All right, that's a good idea. This would be a very
Committee of the
interesting
whole.
search.
Who else on your committee?
Well, the place to start would be redoing the existing forms from scratch.
We need to take a look at them
Try to
and
fix them.
just kind of see where there could be some interplay there. I mean, they were, oh my gosh, so reviewed. Remember, I mean, because the lawyers didn't want it in family law. I mean, it took forever to get
that
the,
would be my suspicion is why they're terminating these interviews, is that in many of the cases, they don't understand what they need. Or in some cases, they're told you've got to go back and you've got to
you
provide.
gotta go find these documents, you gotta go this and that. And we're not gonna be able to solve that problem if they don't have their documents necessarily. But I think there's a way that maybe we could kind of assist, and maybe the lawyers that do family law will not be so threatened by the next, version of these guided files.
Well, a blank form comes up on the screen. In this new iteration, maybe what comes up is, oh, so you only use this form. Before you start, get this stuff together.
You know what, it does tell you that.
And kind of walk them through it.
We're bringing back Mr. Clippett from the Microsoft.
Yeah.
See, you're filing for divorce.
Yeah, exactly. Can I help you? Oh my God.
I see a pretty good application here for occupational driver's license.
I agree.
If we could get a lot more clarity of what's required, what you have to fill out.
Maybe that's our pilot on this, is since we saw that was one where there's a lot of rejections. There's obviously a need for it. It's highly likely that it's almost entirely pro se's.
Yeah.
So maybe this is what we use as kind of our, how can we do this?
So who, Tyler, do we need to talk with? Evan, you or, okay.
You're gonna all be on any of the subcommittees.
I mean, once we kind of go along so that we know, if, you go, you're crazy XYZ, you can't do this, or this wouldn't be possible. Are you doing it? I mean, you are across the nation. So are you using it, any of these tools and any of their kind of other jurisdictions or anything that you're in? Are you seeing this at all?
Oh, AI or guide and file?
AI or?
Not within our products just yet.
Okay.
We call the AI chatbot, but really what it's doing is it's like lookup bot into our support documentation and stuff, but there are plans for it. Just I think
But you have to be careful because you can't assist someone with, if you need help, you need to seek the advice of an attorney.
Right.
You can't seek the advice of a system, and you certainly can't seek the advice from court personnel, so.
Or the little chatbot that's gonna help you, that's gonna pop up on your guide and file?
Well, it depends on the information that you're
And you're
getting
gonna give?
to provide, because you don't want to say.
Do is just telling you when I say your last name or your surname, this is what I mean.
That's the thing, that's a thin line, so you gotta be careful, right, of that slippery slope.
Right. Yeah, no, I agree.
But again, to Jennifer's point, that's part of the context. Remember, chatbot, you are not a lawyer. It is illegal for you to give legal advice.
Well, one
one thing a lot of people are working on, I haven't seen it implemented well yet, is you have like a structured automated form interview.
Yeah.
So, like, and then when it comes down to the narrative, it helps people rewrite their narrative within that structure. And that's very helpful. It helps people really write clear, present their case more clearly. What I've seen is it still leaves stuff out that is important that the person put, cleans it up, but it cuts stuff it shouldn't, or
Yeah.
it's just, that's still an issue.
Totally agree.
But in 5 years, it probably won't be.
No, I just have a huge interest in this, so I bounce around at all this stuff just to see what it can do, and I'm so mad. I just lost the movie thing. They just pulled it, which I probably was a better idea, where you could go on and you just describe a scene and make a video of this. You know that? You know what I'm talking about? Zora. Yeah. Yeah. Well, they were running all kinds of trouble because it was so realistic. They actually pulled it because, it would look like you could pretend you were in, bombs landing in, wherever, and say this is the US Army. You'd have it all dressed. You could do incredible stuff on it. It was horrible in that respect. But it was shocking that it could do it. That just lets you know, how far ahead of all of us this stuff is. And yeah, it's crazy. Okay. Bob, what else do you have?
I believe that is it.
I've got one more thing that our subcommittee brought up, as far as the e-filing service contacts. Each EFSP controls their service contacts functionality. And the new version of Tyler's EFSP has that functionality that the clerks all are looking for, which is that uncheck all service contacts, and then that way they only check who they need to serve. Yes. So if it's something, I don't know if JCIT recommends it or if it's something that just goes through OCA because it's part of the contractor thing with each EFSP. But if the OCA can require that uncheck all service contact checkbox on their configuration, it'll avoid a lot of programmatic filings from these crazy filers that want to add 5,000 parties and serve the president of the United States. And
so what happens,
governor and everybody?
What is the consequence of having, when you uncheck all? So now, how does the clerk react when they have?
So they can uncheck all and then only serve the attorneys or the parties that they know are good parties and not the president or the governor or ABC News or whoever who are not part of the suit.
But how do they know they're not part of the suit if someone is named them?
Because they know by the filing. They know by the paperwork and who's in it and who's not.
And
they sometimes
there's
have
not
served,
room for some. I'm worried that there is room for a real slip up.
Well, sometimes they've served every single employee in their office, and none of the people in their office need that. That sort of thing.
You've got the parties that are named, for instance, in the petition.
Correct.
But they're adding people who are not named in the lawsuit.
Correct.
As people to receive service.
To receive
Courtesy copy.
a courtesy copy?
Yes, they'll just add them.
They're adding them as parties, right? That's what you're talking about. They're not
they'll add them as service contacts. So
who adds them as service contacts?
These crazy people.
How can you do that?
You can add whatever service contact you want in the system.
Oh, you mean, okay, so they are already a party.
The person who's filing it, yes.
Okay, so that's how they're adding service. I just thought you thought, okay.
Right.
And so they're just making requests for service to unknown people.
Correct.
So what do you do when they?
So the clerks right now have to, if they're added in, they have to go and uncheck each one. Say, no, I don't want to send it to here. They'll just check all and they'll just get a whole bunch of emails.
They get them in the mail, by email or?
Email.
Takes a lot of time.
Yes.
Yeah, I see what's going on. Okay. Yeah, no, I see that there could be glitches that occur and some things might go wrong, but I think that's a district clerk call in terms of just having you basically want the status to be, just let the clerk do check all if they want all or otherwise?
So the next time, let's say this crazy pro se just adds tons of people. The next time the attorney wants to file something in the case, they can't uncheck all either in this EFSP. And so they continue to get bogus service.
Yes.
So that's why they were thinking if we had it at each EFSP level, this uncheck all, it will help for these sort of situations. They may never choose it. They may never choose to uncheck it, but it would be there and that functionality would be
So
there.
it's uncheck all and then they check who they want?
Correct.
Okay, yeah. All right, is that possible to do? And we would do it through, Tyler would do it, or the individual counties would do
I
it?
think OC owns that.
Yeah.
Okay, you would do it, okay. Okay, so make that no longer the current state that you go on and it's check all. So make it where or do you have check all, but a way that you can undo it?
Undo it.
Oh, okay. You start with the default of check all.
Correct.
But it's capable of being removed.
Correct.
Okay. That's interesting. If it was a default and you were gonna serve everybody already, why did you have that checkbox if you couldn't remove it?
Well, some of them are just automatically checked. There is no checkbox. That's the problem.
Oh, okay. All right, I see. Okay. All right. So that needs to be reconfigured. Okay. All right. Anything else? Okay, so we've discussed everything on the agenda. Correct, Bob?
Yep.
Thank you.
Next meeting is
I'm taking notes. Okay, June 5th is our next meeting. Is that correct? Thank you. Okay. And we look forward to seeing you then. And so in terms of location, just so we know, in terms of preferences, some of us, we've been at tax, some of us have been at the Supreme Court building. And then this is now a new place. That's a possibility. Does anybody have any preferences about where we go for parking or anything else?
I kind of like the tack.
Tack, yeah, okay.
You're not exposed to where the subject, where you park to the.
Well, you don't pay anything for parking.
Yeah, but there's the weather.
Yeah.
I didn't mind it today. It's a nice, spring day in 60s, but in June, it's probably gonna be
We'll give
Scorcher.
Yeah, nice and hot.
Okay, so tack is is our first preference, right?
Unless you can get us parking in this garage right below.
Yeah.
Yeah.
Very green.
Yeah.
Okay, so that's, we'll take that into consideration, but this is also a nice alternative, so we'll keep that in mind as well. All right, anybody else have any comments, questions, concerns? Okay, with that, we'll
Today again, June 5th.
June 5th. I believe the date we have down now.
Oh my God.
All right, with that, we stand adjourned.
Thank you for reading.
Yeah, good meeting.
Nice to see you.
Well, I've got to go back courtyard.
It's also the